Hello students, KTHM College, Department of Political Science. Myself, Vasudha Chandanshive, welcome you all for the credit subject Human Value and Human Rights. So students, in the first lecture we have seen the introduction of this subject and we have seen the Indian Bills of the Right, and we have gone through the concept of Sarvodaya, that what is mean by Sarvodaya, what are that pillars, how Mahatma Gandhi and from Mahatma Gandhi to after that Jay Prakash Narayan, Vinoba Bhave, how they enforce the means Sarvodaya movement. Okay, now in this lecture, in the second lecture, we are going to go forward with our the very important and very interesting topic, that is the introduction to the Constitution. So students, we will start now. So students, the first unit, human rights in the Indian context. In that, as we know, we are going to discuss about the Constitution. So Constitution is a very, we will say that incredible work of our India, and it is a law of our Indian land. So students, while starting this, before I start this, we know how many acts were passed, how many regulating acts were there in the crown rule and in the traders rule. So from that philosophical history till the constitution was made, how the constitution was made, we know that. Okay, so I will give you a quick introduction about the constitution, that it was in 1934 that the idea of constitution assembly for the India was put forward for the first time by the Amir Roy. And he was, we know him, we have read about him. So he was the pioneer of the communist movement in India, an advocate of radical democratism. So in 1935, the Indian National Congress for the first time officially demanded a constituent assembly to frame the Constitution of India. So in 1938, Jawaharlal Nehru, on the behalf of Indian National Congress, declared that the Constitution to be free, that Constitution of India to be free, and India must frame by itself without the interference of others by a constituent assembly, and it elected on the basis of the adult franchise. Okay, so the demand was finally accepted in the principles by the British government in India, what is known as the August Offer of 1940s. So in 1942, Sir Satford Crisps, a member of cabinet, came to India with a draft proposal of British government on the framing of independent constituent to be adopted after the World War II. So that member means this Scripps proposal were rejected by the Muslim League, which wanted India to be divided into two autonomous states with two separate constituent assemblies. So finally the cabinet mission was sent to India. While it rejected the idea of the two constituent assembly, it put forward a scheme for the constituent assembly which more or less satisfied with the Muslim League. So students, this was the some introductory part of the uh, constitution. So the Constitution of India was drafted under the supervision of, we know, that Constituent Assembly. And originally the Constituent Assembly consists of 389 members. However, a result of partition under Lord Mountbatten Plan of June 13, 1947, a separate Constitutional Assembly was set up for the Pakistan. And as a result, the membership of the Constituent Assembly of India was reduced to 299. Okay, uh, before the partition of Pakistan, the partition was done by the Lord Mountbatten Plan, which was on June 1947. And before that, the Constituent Assembly consists of 389 members. But after the bifurcation, means after the separation of India and Pakistan, the Constituent Assembly of India reduced the member to 299. So the chairman of the Constituent Assembly was Dr. Rajendra Prasad, who later became the first Prime Minister first president of independent India. In order to draft the constitution, a drafting committee was set up on 29th August 1947. So the chairman of the drafting committee was Dr. B.R. Ambedkar. Along with him, there were 6 members also in the drafting committee for the constitution. So after that, the drafting committee completed the task of drafting constitution in 2 years, 11 months and 18 days. So the draft prepared by the drafting committee was later adopted by the Constitutional Assembly on 26 November 1949, and the constitution came into force on 26 January 1950s. So the constitution at that time consists of 395 articles and 12 schedules. So students, this was the some introduction and introduction of the our constitution. After that, the very important is the preamble. So students, what is preamble? So preamble is the Latin word which means preambles, which means introduction. Means the preamble, this word consists of many dimensions. The first one is the introductory statement. Means if one act is there, what that act defines, what that act talks about, means it is given in the preamble. So actual what the preamble works is that it is the introductory statement. It propose the and philosophy, its use, the use of the act. After that, the ideas and aspirations, principles and objective. So this is all consist of the preamble. Means this one word is consist so many things, that is purpose of the act, or we will say we will take an example of our constitution. So the preamble gives the introductory statement of a constitution, its purpose, its philosophy, its uses, its ideas and aspirations. After that, its principle and objectives. So students, the question clicked in our mind is, who drafted the preamble? So Pandit Jawaharlal Nehru, he drafted, means he introduced this means objective resolution draft before the Constituent Assembly on 13 December 1946. And after the India got independence, it became the preamble source of our independent India on 22nd January 1947. We adopted it as that objective resolution as our Indian preamble. So the next thing about the preamble is that the amendment was there. The 42nd amendment was there. So the 3 words were introduced. That were socialist, secular and integrity. So these 3 words were introduced. It's very main from the exam purpose. And after that, when we go through our preamble, the first line is that we the people of India. We the people, means it is the source of preamble. Means no one can interfere in our country or our state. Means the we the people, it means that behalf of the people, means behalf of the people in the sense the Constituent Assembly will prepare the uh, uh, constitution behalf of the Indian people. And its nature, the nature of the preamble, the words, the important words like sovereign, democratic, so secular, socialist and republic. It defines the nature of our constitution. It defines the nature of our preamble. After that, the important word, just like justice, equality, liberty and fraternity, it gives the objective of our constitution. And the very important thing which is mentioned, that is on 26 November 1949 we adopted preamble. Okay. So students, we will see some important words in our preamble. The first word is sovereign. So what it means? It means independent country. Means if any internal affair is there, we will solve it by our own. No external interference should be there. It is very simple. What is sovereign? Okay, now what is socialist? This socialist, it is very important. It is under 42nd Amendment Act. It was added to our preamble. So we when we see when we hear the word socialist, we directly compare this socialist to the communism perspective, that that means of production is controlled by the government, means halfly or partially it is controlled by the government. But in our constitution, the socialist means the principle given by Mahatma Gandhi and Jawaharlal Nehru was implemented, means welfare of the state, means there is no mode of control or mode of production is controlled by government partially or wholly. It is only the purpose, it is only the motive of the welfare of the state. It is very positive. Okay, this is the socialist, this word. After that, secular, it is also added by the 42nd Amendment Act. Secularism means it is the in the positive perspective, means our constitution has given secular as a word in a positive perspective, which means freedom to practice, profess and propagate, that state has no religion. Means as we take an example of France, in that country religion, it is means secular is opposite to the religion. They have to follow a specific country's religion, whereas in our India it is opposite. We have freedom to practice any of the religion of our choice. Okay, after that, the fourth very important word is democracy. Demo means people and cracy means rule. So the constitution of India means the government means it is elected by the people. Means there are two type of government. It is election, which are direct election and indirect direction election. So the indirect election is in our India, which is representative election. Okay, means the rule by the people. After that, the fifth word is republic. So republic, our real head of our state is prime minister and the nominal head is president, but they both are elected. So the head of the state is elected, not nominated by the hierarchy. Means no, not in that means republic is opposite to the monarchy. There is no means head of means nepotism or monarchy, that the king's son will be king. No, there is election in our country. Okay, and a very important and interesting thing of our preamble is the question is that is preamble is a part of our constitution, and can it be amendment can be done. So article 368, power of parliament. Okay, by this article 368, the amendment can be done. Parliament has the power. So in one hand we will say the case of rebellion, union and exchange of enclaves, and on other hand we will see the Keshavananda Bharati was the state of Kerala. So when we will learn two cases on two sided, we will get a clear dimension, that a clear idea is of these two questions: is the preamble a part of our constitution, and can it be amendment? So when the first case, the exchange of enclaves were there, so 368, any part of the constitution can be amendment, but they said in this case, the first case, they said that preamble is not part of our constitution. Preamble is not part of our constitution and it cannot be amendment. And but they forgot one point, that was that our constitution, every part of our constitution are adopted and enacted. So we can amend, we can do the amendment of any part of our constitution. So on the other hand, the Keshav Bharati case of state of Kerala, they took the point forward, and they said that like any other part, preamble is a part of a constitution, because every part of our constitution is enforced and enacted, and by the power of power of Act 368, we can amendment the preamble. But the 368, this article says that we can do the amendment of any part. We can do the amendment of the preamble, but the basic features cannot be disturbed. So now the question is that then the three words which were added, the secular, then socialist and integrity, but this word gave the strength to our preamble, so that's why the three words were added. Okay, so students, this is about the preamble. I think it is understood by you. What after that? That is fundamental rights. So fundamental rights, we know we have six fundamental rights. Okay, so students, we are going to learn about our fundamental rights in our Indian context. So article 13 is the cornerstone of our fundamental rights. This article imposes restrictions on the state not to enact any law that constitutes an infringement to fundamental rights. So this article empowers the judiciary to keep a wiggle on acts of state and its agency to nuffill any law which brings in any kind of unreasonable restrictions on the free exercise of fundamental rights. So students, from article we 14 to 32, we have our fundamental rights. We will see them one by one. The first one is right to equality. So equality constitutes an important integrant for the free exercise of fundamental rights. So this means all people are equal in eyes of law and have equal protection of laws. So according to Addice, through a section of people may enjoy certain preferential treatments for justifiable reasons. The concept of equality cannot be constructed as discriminatory in nature. So equal protection of laws connotes that all person placed in a similar situation will have a nextitude with the purpose for which the laws is enacted. So the concept of equality under Article 14 is applicable to citizens as well as to the foreigners. The concept of right to equality is dealt under Article 14 to 18 of the Constitution. In this article, certain concessions are extended to the various sections of people, taking into consideration of their social, economic, political, and cultural background. So, this concession extend to those group of people are applicable only to them. The philosophical behind this conception is to uplift and disadvantaged groups on par with other socially developed groups. So this type of concession extend to various group is fully justified under the concept of equality. And equality begin a wider concept of law. Laws can be applied only between equals and an equal footing, but not between equals and unequal. So this is Article 14. Now after that, the Article 15, which is prohibition of discrimination. Okay, this article emphasizes and draws the protections of equality before law as stated under Article 14. At the same time, it clearly justify concession that are extended to women, children, and socially and educationally backward classes of citizens, and scheduled castes and scheduled tribes. As reasonable classification of wipe out their inequalities in applying the spirit of equality before law and equal protection of law. Therefore, the concession extend to various group of people in no way constitute discriminatory. So this is the Article 15. After that, the Article 16 is equality of opportunity in matters of public employment. So this article is a further extension to meet a requirement of equality under Article 14. According to article, all citizens should be equal, given an equal opportunity to public employment without any kind of discrimination. However, the concession extend to various groups by the state under this article. No way constitutes discrimination to a general philosophy of equality among the citizens. At the same time, it has to be remembered this article is no way conference a right on citizen to pursue a job on a guaranteed base. So this is Article 16. After that, the Article 17 is abolition of untouchability. So students, when we see our Indian constitution, means as we go back at the back 70 years back, we know the untouchability, how it was practices. So now in our article 17 we have introduced the abolition of untouchability. So this article is elaborated of the concept of equality guaranteed under the Article 14, though there is no definition what constitutes as untouchability in the constitution, and as well as in the Protection of Civil Rights Act in of 1955. The word untouchability signifies any kind of discriminatory practices that are adopted by a section of people to any of disadvantaged section of people in the society. So this article is similarly to the 13th amendment of the Constitution of America, which abolished slavery and in the tune with the spirit of international law of human rights. So students, try to link this article with the human declaration. We have the same right here, I means our fundamental rights in all over the globe are the same. So please link, try to link the fundamental rights. Okay, after that we will see the Article 18, abolition of titles. So according to this article, no citizen of country is permitted to receive any title from any foreign countries. However, there is no bar on the government of India to confer various title and honor to its citizen based on their performance in various fields including defense services. At the same time, none of employees of government while in service are entitled to receive any kind of titles or any kind of job from or under any foreign state without the prior session of the President of India. Okay, so this is the article, this is Article 18, which is abolition of titles. But our India government, which gave Miss the award like Padma Bhushan, Padma Bhushan, Bharat Ratna, they are not banned. Okay, there is no ban on that. After that, there is Article 19, right of various freedoms. So there are various freedoms such as we will say freedom of speech and expression. First one is that. After that, assembly peacefully without arms. After that, move freely throughout territory of India. After that, to reside and settle in any part of the territory and to practice and profession any profession or to carry any occupation, trade or business. In original constitution, right to property was also part of our constitution, but wait for a minute students. So it was there, but however the 44th Amendment Act, we all know the Constitution of India in 1978 has converted it into a legal right than fundamental rights under Article 300A. Okay, so we should know the difference between the fundamental rights and legal rights. That fundamental right cannot be taken away by the state under the grasp of law. On legal right can be taken away from the state under the authority of law by paying appropriate compensation for such deprivations. Okay. However, the judiciary is empowered to examine whether such deprivation is legal or not. Okay, so right to freedom of person. So from Article 20 to 24 consist of right to freedom of person. The provision under this various articles constitute as basic rights in order to receive the equal treatment and equal protection of laws under Article 14 of the Constitution. The right of freedom to persons are available to all persons and not confined to cover only the right to citizen of India. So the article 20 to 24, the first one is article 20 is freedom to protection in respect of conviction of offenses under article 20. So and after that, the protection of life and personal liberty under article 21, and after that, the protection against arrest and detention under article 22, and after that, the article is very important, that is article 23rd and 24th, that is right against exploitation under article 23 and 24. The important right has adopted by the Constituent Assembly based on the jurisprudential visa of international law of human rights. So according to this right, no person can be compelled to engage in any work that degrades the dignity and constitution as a contravention of life and liberty of an individual. For example, work like forced labors, after that prostitutions, trafficking, etc. So it's also guaranteed that the children not to be employed in working below the age of 14, which deprives that tender age of childhood. So a number of convents, national legislation, policy of governments and judgments and judicially clearly advocated that this is right to need to be protected at all time, and a duty has been cast both on the state and on the people to keep a will and watch against the breach of this right. So at the same time, the state is empowered to exact a compulsory services for public purpose without any discrimination, either to defend and sovereignty of the nation or in the times of major calamities. Okay, it is very important fundamental rights. After that, the fundamental rights from 25 to 30 is right to freedom of religion and cultural and educational rights, and right to rights of minority under article 25 to 30. So being a land of many religion, in a tune with the philosophy of preamble of our constitution as a secular state. The state has no religion and all religions are equal in the eye of law. This articles advocates citizens to profess, practice, and propagate the religious practices and sentiments of any religion without hampering the rights and sentiments of other religions. So peoples of every religions are free to establish and maintain any institute for religions and charitable purpose in accordance with the provisions of various laws of country. So no government institute or educational institute or institute funded any managed wholly or partially with the support of that state at no point or time advocate and instruct any religion activity. However, any institute established for the promotion and protection of right of minority can impart such education which may help them to protect their cultural perspective in preassembling under article 29 and 30 or any other law that are enacted for time to time. So this in spite of recognizing of the rights of minority by international law of human rights and as well be by the Constitution of India, it is surprising to note that the term minority is confined only to religious perspective and no definition is provided to define what constitutes a minority. So this is article 25 to 30. After that, we know the article 31, it has eliminated in our fundamental right, which was right to property. After that, article 32 is right to constitutional remedies, and it has given the five writs, which is habeas corpus, the mandamus, prohibition, quo warranto, and certiorari. So habeas and purpose, it means to produce a body before body before a court or to answer a court. It is article under article 32, and after that it is mandamus. We will go through it in a short. Okay, it is literally means a command issuing from a court directed to any person, corporation, or interference court or authority to an act to refrain from any act which falls within the judiciary. After that, the prohibition. Prohibition is a judicially writ compelling the courts entrusted with judicial duties to keep within the limits of the judiciaries. And after that, the quo warranto. This right issued against a person who holds a public office to inquire whether he possesses the authority or not. And last one is the certiorari. The court issuing the writs act is in its superiority judiciary. It is only concerned with the conduct of the tribal before the inferior court and whether the court has followed the law or not. So hence it can be said that the writ certiorari can only be issued when there is error of law apparent on the face of record, and not when there is error of fact. So students, this is the lecture about our constitution, our introductory part, preamble, and our fundamental rights. And in fundamental rights we have seen our fundamental rights and the article 31, which was eliminated in our constitution, and it was given the legal right. Means it was the fundamental right before, now it is the legal right. And we have seen the difference between fundamental rights. So students, we have done with our second lecture. All of you, thank you.